This is the afternoon session of the first day of a two-day session of our March docket on the Tennessee Court of Criminal Appeals. My name is Robert Wiedemeyer. I'm from Oak Ridge, Tennessee, but I live in Nashville now and serve on the middle section of our court. It's my honor to serve with two colleagues today from the western section. To my right, Judge John W. Campbell, Sr. from Memphis, Tennessee, and on my left, Judge Matthew J. Wilson from Jackson, Tennessee. As a preliminary announcement, first of all, we welcome our law students from the University of Tennessee College of Law, and we're happy to have you here, and hope it's a good experience for you. And as far as other matters, quickly, both sides have 20 minutes. Each side has 20 minutes to argue. If you're representing the appellant and you wish to reserve some of that time for rebuttal time, let us know before you get started, and the clerk will help keep up with that with our light system here. We have read the briefs on these cases, and in most cases we have not gotten into the actual record, but we are familiar with the case as to the information contained in the briefs. So if you want to tailor your arguments accordingly, that's fine. I think that's all of the preliminary matters we have to deal with this afternoon. And are there any preliminary matters that you're aware of? All right, if you'll call the first case, please, we'll get started.
State of Tennessee versus Darrell, Hardin.
All right, this is Mr. Reagan, is that right?
Yes, sir.
All right, sir.
Randall Reagan of the Knox County Bar, here for appellant Jonathan Hardin. This case, as your honors know from reading the briefs, involved an aggravated kidnapping. Started out as an especially aggravated kidnapping. Mr. Hardin was found guilty of the lesser included offense of aggravated kidnapping. A crucial issue in this case was the presence or absence of a box cutter. And to signify the significance of that, the term box cutter appears in the transcript over 400 times. So this was a very crucial part of the evidence. In this case, Ms. Fugatti, who was the alleged victim in the case, and Mr. Hardin got into an argument at their apartment. During that argument, according to the testimony of the roommate, Bryant, Mr. Hardin shoved Ms. Fugatti. Ms. Fugatti testified that Mr. Hardin dragged her out of the apartment, forced her to leave the apartment. Bryant testified that he made them both leave because they were in his apartment fighting. After they left the apartment, they got to Mr. Hardin's car. And in Mr. Hardin's car, there was a lady there, Toya Reeves. There's some contradictions in the proof about how Ms. Fugatti got into the car. Ms. Fugatti said she was forced into the car, she was beaten at the car, she was yelled at the car, and said that Mr. Hardin forced her into the car. Ms. Reeves' testimony, as we presented it at the motion for new trial, she would have said that there was no fighting at the car, there was no yelling, and that Ms. Fugatti voluntarily got into the car. At any rate, later on in the evening, police located Mr. Hardin and Ms. Fugatti in Mr. Hardin's car at a convenience store parking lot. This was the middle of the night. Mr. Hardin was in the driver's seat, passed out. Ms. Fugatti was sitting in the passenger seat. Well, I won't take that back. I'm not sure whether she was in the passenger seat at that time or whether she was in the rear seat. She ended up in the rear seat after the police got there. Didn't agree whether she was there or not at first. But at any rate, Mr. Hardin was taken out of the police car immediately. There had been some conversation text conversation between Mr. Bryant and Ms. Fugatti in the presence of Lieutenant Cash, who also testified to KP Lieutenant Cash. That's how they knew where they were. They took Mr. Hardin out of the car immediately, handcuffed him, put him in the back of his patrol car. arrested him immediately. During the conversation between Officer Townsend and Ms. Fugati, Officer Townsend asked her what happened. She told him this story about being forced out of the apartment. And Townsend asked her if he had a deadly weapon with him, if he used a deadly weapon. And she says, well, he has a box cutter. He owns a box cutter, but I don't know if he has it with him. In the investigative reports, in the arrest warrant, nothing is said in any of those about the existence of a box cutter. Townsend testified that after he arrested Mr. Hardin, after they got Ms. Fugati into the ambulance to take her to the hospital, she had some injuries to her face. He says that he conducted his inventory search and that he found a box cutter in the car, but that he did not collect it because he did not think it was connected to the case. Lieutenant Cash testified that he was there at the scene, and he says that he saw Officer Townsend with the box cutter in his hand. So that's basically what the proof was at the time. After I did not try the case, I came on for motion for new trial and for the appeal. I noticed in the discovery there was nothing about any kind of inventory of the car, no inventory report of any kind. So I had my investigator go and I told him there's got to be an inventory report, and that you can see in the standing orders that we introduced into evidence motion for new trial from KPD, they are required to do a detailed inventory report detailing the contents of the car, each item of the car. After about 4 or 5 times of requesting the report, my investigator went to the KPD property department, records department, says there's got to be, he's a former officer. He knows what should be there and what shouldn't be there. He said there's got to be an inventory report. They finally gave us the inventory report. And when we got the inventory report prepared by Officer Townsend, it says the only contents of the car was clothing. Nothing at all said about a box cutter.
That's all it said was clothing or various clothing?
No, it said clothing.
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 Did your investigator, was he in a position to examine what was actually in the car? Was that ever in the record?
That's another issue here, Judge.
Okay.
Is that the car was seized at that time. This is, I think, sometime in December. 2 weeks later, the car was auctioned off, and so it was gone. That was even before the preliminary hearing in this case. So there was no way, nobody could go to the car and examine it and see what was in the car, see what was left in the car. Because the car was destroyed, as far as we're concerned. The car was done away with before anybody had an opportunity to go investigate the car, to investigate this case, see if there indeed was a box cutter in that car.
And that is the basis of your alleged Brady claim, right? The lack of box cutter being listed on the inventory.
Well, the basis of the Brady claim is that this tow report, this inventory report that said only clothing was in the car was not disclosed to the defense. If you look in the hearing on the motion for new trial, both the trial counsel and his investigator both testified that they asked for any reports at KPD and were told there are none. Trial counsel testified at motion for new trial that he was represented to him many times by the state that there was no box cutter found.
Tell me about, I don't know if the state mentioned it in their brief, but it was somewhere in the briefing about the use of a video, maybe a body cam video that didn't show the box cutter, the use of that to impeach one of the witnesses.
Well, here's what happened with that. The body cam videos were not disclosed to the defense until about a week before trial. And Mr. Pate said because he had been told that there was no box cutter in the car, he didn't feel it necessary to review those tapes to see if there was any box cutter, because they said there wasn't. And also, and a week before trial, there's probably, I don't know, 8 to 10 hours of video from different perspectives. But Townsend's, it wasn't his body cam, it was a dash cam. His dash cam was introduced into evidence, and I think it's Exhibit 6 or 7 at the trial. But we also introduced it at the motion for new trial, along with some video stills of that. And apparently from the video stills, you can see that he doesn't have a box cutter. And Lieutenant Cash said that he saw the box cutter Townsend said he got the box cutter out when he was doing the inventory search, just as part of his inventory search. And Lieutenant Cash said he saw Townsend with the box cutter in his hand. But then when you review the tapes carefully, when you have time to sit down and do that, you can see that Cash wasn't anywhere around when this inventory search was conducted. None of the other officers were around. It was Officer Townsend alone.
And was that video used at the trial and the motion for new trial, or just what you referred to at the motion for new trial?
Judge, it was introduced at trial, and I don't recall right now what use was made of it. I think it may have been used to show Ms. Fugatti's statements to the officer. Okay. But again, that was at a point in time when trial counsel had no reason to expect that anybody was going to say there was a box cutter in the car. And, the failure to disclose the report that said clothing only, the failure to disclose to the defense that these officers were going to say, or Townsend was going to say he found a box cutter in the car, led to defense counsel in his opening statement to the jury saying no box cutter was ever found. They did a search of the car and did not find a box cutter. And the assistant DA that prosecuted the case said during the trial, some break in the trial, this is in the record, told the judge, Officer Townsend told me in a meeting that he had found a box cutter, and I did not tell the defense about it. So trial counsel was essentially ambushed with a box cutter in this case. Oh, and I'm sorry, I meant to reserve 5 minutes of my time for rebuttal. I'm sorry. If I may do that now. But at any rate, that's a very crucial issue in this case. He was convicted of a lesser included offense of especially aggravated kidnapping. But there was, the jury had some reasonable doubt about whether the box cutter was ever there or was ever threatened the use of it. And he would not have been convicted of especially aggravated kidnapping. Instead of serving 100% sentence, he'd be serving a 30% sentence, a much lesser sentence.
So he was convicted of the lesser included offense of aggravated kidnapping?
He was charged with especially aggravated kidnapping
Right.
and charged with aggravated kidnapping.
He was convicted?
Convicted of aggravated kidnapping, yes.
Which is a lesser included.
It is a lesser included, yes.
All right.
And, he was also convicted of the lesser included offense of ag assault, which, the jury had some doubt about this box cutter. But when you have two officers testifying that they found a box cutter in the car.
But apparently the jury didn't accept that.
Well, they had to have accepted it at some point because they convicted him of possession of a deadly weapon or threatening the use of a deadly weapon during the offense.
But not of aggravated assault, or they just convicted of the assault?
Convicted him of simple assault there.
All right. Can you punch in 5 minutes for his rebuttal? All right, thank you.
Good afternoon, General.
Good afternoon, Your Honors, and may it please the Court. My name is Garrett Ward, and I'm here this afternoon on behalf of the state of Tennessee. Your Honors, this Court should affirm the defendant's convictions for, and to just address your question, Judge Campbell, for simple assault and aggravated kidnapping, both of which were lesser included offenses of the charged offenses of aggravated assault and especially aggravated kidnapping. These convictions should be affirmed because defendants' evidentiary and constitutional complaints don't have any merit. Your Honors, as I understood opposing counsel's argument, he devoted his time at oral argument to solely to a Brady claim. So I'll address that claim in my argument and rest on my brief for the remainder. Obviously, if this Court has questions about the other issues, I'm happy to answer them. But specifically regarding this Brady claim, as the claim was presented in the defendant's brief, He is raising a Brady claim about a single piece of paper that was discovered in between the trial and the motion for new trial. This piece of paper is, I believe it's Exhibit 2 of the motion for new trial. It's the second exhibit introduced. The piece of paper is entitled a tow ticket. It contains, several pieces of information. It's filled out by several different individuals. But in summation, the evidence at the heart of this Brady claim is a tow ticket that in the first section is just sort of logistical information about Officer Townsend ordering a tow. Lists the time the tow was placed, the location where the tow truck needed to go, logistical things. The second section, which from my examination seems to have been filled out not by Officer Townsend, but by the wrecker who came and picked up the car, has some other information in it, including a sort of a one-line entry item for property and vehicle, and it just says clothing. That's all this tow ticket says. And I think really discussing and providing this court a little bit of detail is about this tow ticket is crucial for this argument for this Brady claim, because as defendants proceeding under Brady, his burden is to establish for this court that this tow ticket was material, and he can't do so here, Your Honors. And I'd suggest to this court that there are really three separate but a little bit interrelated reasons that demonstrate why this piece of evidence that was discovered in between the guilty verdict and the motion for new trial isn't material. First, this document does not really hold itself out to be a full and complete inventory of the car in this case. It is largely, as I said, a logistical document, an ordering of a tow, confirmation that the tow is of this vehicle is going to occur, and then some drop-off information. That's primarily what this document is. The document doesn't purport to be a full inventory report of this car. There was certainly a full inventory report was requested pre-trial. The response was that there doesn't seem to be a full inventory report, and still before this court, we don't have anything that resembles a full inventory of this car. We have a tow ticket that has sort of a one fillable field regarding property that just says clothing. It's not specific as to how many pieces of clothing, style of clothing. All this document says is clothing. And I think the nature of the document really plays into how significant is it that this document doesn't say the words box cutter. Because I think defendant's argument is that it is material that this document didn't say box cutter, because if the jury had known that this document, this tow ticket, didn't say box cutter, then they might have reached a different verdict. And without it, we don't have confidence in the jury's verdict. And that's, of course, the materiality standard, is does the missing evidence undermine our confidence in the verdict? In the absence of the phrase or the words box cutter in this document that is an ordering and then confirmation that a tow occurred, really isn't the same as if there had been a full inventory report that listed every little last thing specifically that was found in this car. And if that report didn't say box cutter, that's a slightly different story as compared to this, which is not a document that is principally produced for the purpose of laying out the inventory of the vehicle. So that's the first reason I'd suggest this court, the evidence isn't material. Secondly, Your Honors, as opposing counsel recognized, this is hardly the only thing in this case that suggested that there wasn't a box cutter found at the scene of the arrest. There is referenced in the motion for new trial, defendant's trial counsel talks about his possession of an incident report. that incident report makes no mention of a box cutter being found. Indeed, sort of all throughout this case, there is a lot of discussion about the box cutter, and there's a lot of discussion about the fact that the state doesn't have it, that the state can't hold this box cutter out and give it to the jury. Admittedly, 2 officers did testify about, seeing this box cutter when they were inventorying the car. But it was really a live issue for both counsel for the state and counsel for the defendant, and thus for the jury. Was there or was there not a box cutter? And there was already documentation in trial at the time produced by law enforcement, definitively produced by law enforcement, as opposed to this document, which is at least partially produced by the driver of the tow truck. We know that he signs this document. His signature is the only one that appears on the tow ticket, is the wrecker's signature. So we have this document from law enforcement that doesn't talk about the box cutter.
Were Mr. Reagan talked about the warrants and the police reports, I think were 2 of the areas. Were those as well as the other documentation you're referring to, were the state's witnesses, the police officers, impeached with those documents?
They were certainly cross-examined about the fact that they didn't mention it in the report, Your Honor, absolutely.
So you say there's a box cutter now, you didn't put that in your report, something to that effect?
Exactly, and I think what that really speaks to is how, really cumulative this tow ticket would be. We've got a piece of paper that they produced that already doesn't mention the box cutter. The officers were asked about that at trial. Compared to that, sort of the additional, evidentiary value and impeachment value that would have been provided by this piece of paper, which again is of mixed authorship, is really minimal. The jury already had this evidence suggesting that the box cutter wasn't found. Yes, there's testimony that it was found, but it's not as though this tow ticket contains the novel idea that law enforcement has produced, something that suggests that they never found the box cutter. That was already in the record. That was already considered by the jury. And I think, Your Honors, that really brings me to my last point, and perhaps the strongest argument in favor of this evidence not being material, and that's that the jury outrightly rejected charges that would have necessarily meant they found that the defendant possessed or used a deadly weapon. Judge Campbell, as I mentioned earlier, the defendant was convicted not of especially aggravated kidnapping, which undoubtedly would require the use of a deadly weapon, but only of aggravated kidnapping, which could be accomplished by possession of a deadly weapon or just by the threatened use of one. And we have strong testimony from both Bryant and Ms. Fugati that the defendant did threaten to use a box cutter against her. And the jury selected that charge rather than the one that would have necessarily meant they thought he had a box cutter. And it's really the same story for aggravated and simple assault. He was charged with aggravated assault by a deadly weapon. The jury didn't return a verdict of guilt on that charge. They rejected it and came back with simple assault. So I think that sort of further lessens the materiality argument that the defendant's now trying to make. This evidence would have been, perhaps greatly significant if we were dealing with a defendant who was convicted of offenses that required the state to prove he used a deadly weapon. Mr. Hardin wasn't convicted of those offenses. Those offenses were specifically rejected by the jury, perhaps because the state couldn't produce the box cutter at trial. But as far as how material is this tow ticket to a simple assault and aggravated kidnapping, it's not. Because this evidence isn't material, defendant's Brady claim must necessarily fail. I went to, there was a question, I believe, Judge Wilson, you asked about. There's discussion of the body or dash cam videos. Sort of the evidentiary nature of those is a little complicated, so I'd like to just clear it up for the court. An audio portion of that video was introduced as Exhibit 16 at trial. The full video was introduced as Exhibit 32 and is only for identification purposes, so the jury only heard this audio. And then at the motion for new trial, the full video is introduced for evidentiary value at the motion for new trial is Exhibit 7. So all the jury hears is the audio. That's what the jury gets regarding the surveillance videos. Your Honors, that really concludes what I've got to say on the Brady claim. If this court has questions about any of the other issues, I'm happy to answer them. Otherwise, I would ask that you affirm the judgment of the trial court.
All right, thank you, General.
Thank you, Your Honors.
Certainly.
I think you've got 5 minutes.
Yes, Your Honor. Thankfully. Judge, I would correct Mr. Ward in one aspect, is during the cross-examination of Cash, neither in the cross-examination of Cash or Townsend by defense counsel were they asked about these reports that don't mention box cutters. The arrest warrant itself was prepared by Cash, Lieutenant Cash, and he puts in that arrest warrant. It was prepared that same night that Mr. Hardin kidnapped her brandishing a deadly weapon, a box cutter. The arrest warrants were introduced as evidence. The incident reports that do not mention the box cutter were not introduced as evidence, and there was no cross-examination of those officers about the absence of the box cutter in those reports. Trial counsel was so gobsmacked by the testimony from Townsend and Cash that they actually saw a box cutter in the car that he had almost a perfunctory cross-examination of Cash. It was very devastating to them. And I don't mean to, but I didn't have enough time to address the ineffective assistance of counsel, but at the heart of that ineffective assistance of counsel claim is trial counsel's failure to call Toya Reeves, the lady that was in the car with them, who also would have testified there was no box cutter. And you will see in the transcript of the trial, when asked if he's going to present any more proof after Mr. Hardin testifies, defense counsel says, well, no, Judge, we had a witness that was there, but she didn't want to come, so we're not going to call her. He testified in motion for new trial that it was a strategic choice not to call her because apparently there were some inconsistencies in the first statement she gave them and later statements. But one thing they testified to was always a constant in her statements that she gave to them was that she never saw a box cutter and that Mr. Hardin did not threaten Ms. Fugati at his car.
Back up a second.
Yes, sir.
Trial counsel decided not to call Ms. Reeves because
Yes,
she didn't want to testify and there were some issues.
Yes, Your Honor.
And she did not testify at the motion for new trial.
Well, she did not, but what happened at the motion for new trial was we had scheduled the motion for new trial several times. We had Ms. Reeves there 3 times, and each time the state was asking for a reset because they couldn't get trial counsel there. So I said, I've got her here, and the state said, well, we'll agree to let her testimony come in by affidavit, and so that affidavit is in the record.
Okay. Now, let me go back to the question I asked you originally about what he was actually convicted of.
Yes, sir.
And the state made a comment that kind of where I was thinking about is that aggravated kidnapping can be accomplished by the use of a deadly weapon or the threaten to use a deadly weapon. And we've
Yes,
had
sir.
aggravated robbery charges. Somebody comes into a store, says, I've got a gun here, give me your money, I'm going to shoot you. The jury, there's no gun seen, but the victim, if the victim has reason to believe that there's a weapon there, it can be aggravated robbery. Or the jury can say, I don't think there was a gun, it could be robbery. In this particular case, the jury could say, I don't think there really was a box cutter. However, the victim thought there was, and therefore it's aggravated kidnapping. So they could reject the idea that he had a box cutter, but still convict because they thought that he threatened the use of a box cutter. And apparently there was testimony that he was threatening to cut this person. So the jury could reject there was no box cutter, but still convict on aggravated kidnapping.
Yes, Your Honor, that's true, but but Townsend and Cash's testimony that there was a box cutter present certainly makes it more likely that there would have been a threat.
But the jury makes the decision about credibility and about whether or not, and again, if there was nothing produced, of course, the state couldn't produce a box cutter. The jury could say, well, we're going to give the benefit to the defendant and convict on the lesser because we don't think there really was a box cutter. Because again, they convicted him on assault and not aggravated assault. If they'd taken the 2 officers for their word and said that was the deciding factor, they would have convicted on aggravated assault and not on assault.
That's true, Your Honor, but
Because they heard the proof, and they're basically the last call on the facts.
I understand that, but the crucial evidence that an eyewitness who was there says there was no box cutter and no threats,
Okay?
and that witness wasn't presented.
But the jury still convicted on an offense that would have also said that there was no box cutter.
That's true, Your Honor, but again, if it makes it more likely because a box cutter was present, that makes it more likely that there was a threat to use it. If the defense had had this favorable evidence that would have enabled them to conduct further and possible fruitful investigation, as we say it in State versus Brewer, then they would have been able to investigate, find the tow truck driver if the tow truck driver prepared the inventory report, which I don't think he did. I think that was Officer Townsend.
Let me go back to one other thing. I know you're out of time. Let me go back to one other thing you said about the affidavit.
Yes, Your Honor.
Now, you made a comment that there was some information she had that wasn't helpful.
Well, Mr. Trial counsel and his investigator both testified that she gave them an initial statement that was not as favorable as a subsequent statement she gave to them,
Okay.
and that was the reason they didn't call her.
Okay.
Okay. However, given the crucial nature of this box cutter testimony in this case, her statements were always consistent in that she never saw a box cutter.
And I guess if we're getting into trial strategy, which, is usually kind of hard to do at this stage of the game, but, a lawyer makes a decision about, you've got a favorable piece of evidence, but you have to take the whole package if you put a witness on the stand. And if that witness has been inconsistent, that could justify, even for a piece of favorable evidence, not wanting to get into maybe some things that would be harmful. And that's kind of what a trial lawyer has to decide, the cost and benefit.
Yes, Your Honor, and I think that the inconsistency that they were worried about was initially Ms. Reeves, I think, said that Mr. Hardin shoved Ms. Figatti into the back seat. Okay. Subsequently, she said she got in on her own. And one thing she was always consistent about is that there were no threats and there was no box cutter. And Mr. Spate testified at the motion for new trial that his strategy initially was there was no offense committed at all, which I submit is not a reasonable defense theory when you've got a bloody picture of Ms. Figatti's face. And Mr. Hardin took the stand and admitted, at the very least, to an assault. That just kind of, it doesn't seem to me that that's a reasonable defense strategy at all, and those decisions made in support of that strategy weren't reasonable. Thank you.
All right, thank you, Mr. Reagan. General, thank you. Well argued, excellent briefs. We'll take it under advisement. Call the next case, please.